Today we're going to talk about how much money you need to have before you have a will. My name is Gregory Singleton. I'm an estate planning and probate attorney who lives in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities as well as greater Minnesota alike. Just as a reminder, if you like what you see in today's video, please feel free to smash that like and subscribe button below. It sure helps support the channel. So, how much money do you need to have before you get a will? This is a question that actually comes up quite a bit. Is there a magic number that says, yes, at this point you need to get a will? The answer is there is no magical dollar amount. The question of whether you should have a will or not is more of a question of strategy, of what strategy you should use and need to use in order to accomplish your goals with your estate. Some people think that the will is unnecessary. They do everything they can to address all their assets before they die so that a will is not even in the picture. For instance, if you have real estate, you can put your real estate into transfer on death deeds so that when you die, it automatically transfers to someone else, regardless of what any will would say. You can put your bank accounts into joint accounts, into payable on death deeds or payable on death accounts. That way the assets will transfer immediately to whoever that joint owner is or whoever that designee is. A lot of people think I don't need a will because all my assets or my primary assets are in my 401k or my IRA or my pension, and those have beneficiary designations. Some people might think, well, my primary asset actually is life insurance, so that has a beneficiary designation, so it doesn't matter what a will would say. But still, that doesn't answer the question of do you need a will or not. So to approach this question, I found 5 different questions, and I guess situations where you might realize that you should have a will or maybe you don't need a will. Question number 1 is, who do you want to have your stuff? If you don't have a will, we're going to follow the Minnesota intestacy statutes. These are a law that basically gives a hierarchy of individuals that will get your things and your assets and your property when you die if you don't have a will. And it starts off with giving everything to your spouse if you have a spouse. If you don't have, or if you have no children or all your children are between you and your spouse, then your spouse will get everything. If one of you has a child from a previous relationship, then your spouse will get the first $225,000 plus 1/2 of the balance of the intestate estate. Beyond that, then it goes to your descendants by representation. Your stuff will, after if you have no descendants and no spouse, then it'll go to your parents. With no parents that are alive, it'll go to your parents' descendants, so basically your brother and sister. If you don't have a brother and sister, that'll go to your grandparents, and other than that, it'll go to other kin, is what the law says. So that might be okay for some people. Some people may think, yeah, I want all my property to go to my spouse. That's fine. Here's a couple things to think about. First of all, if you want to do anything different, then you need to have a will. You can't just hope and pray and expect it's going to turn out right. It's going to follow, the courts will follow the statutes to the letter, regardless of what the circumstances are. Say you have an estranged father that you haven't spoken with in 20 years. Your estranged father, under the statute, will still be a beneficiary and receive and be your heir if you don't have a will, if you don't have a spouse and descendants. If you want to disinherit someone, such as maybe your estranged son or your estranged father, you can't do that unless you have a will. It doesn't matter how many people show up and testify and say this person hasn't been in their life for 30 years. It doesn't matter. They follow the statute. If you're in a situation where let's say you have 2 children, and one of them took out a loan from you of $100,000 so they could buy a house, and they haven't paid it back. Now you've got your estate and you're divvying it up between the children, and you think to yourself, maybe the child that took the loan out that hasn't paid it back should receive less in their inheritance than the one that hasn't taken out the loan. So you can balance things with a will. You can't do that if you don't have a will. If you don't have a will, the courts are just going to look at it and say, well, we split it by representation, you each get half, that's it. If you have any children that are unadopted, they're not going to receive anything unless you have a will. And this is a big one, and this is probably the biggest one, if you have a partner you are not married to, and let's say you've been together for 10, 15 years, but you just never got married, they receive nothing under the statutes. It doesn't matter how long you've been together, how much you acted like a married couple. There's no such thing as common law marriage in Minnesota. So if you have a partner like this, you're going to want to make sure to have a will to leave them something in your estate. Question 2. Who do you want to distribute your estate? Who do you want to be your personal representative? In other jurisdictions, they call it an executor or administrator of the estate. If you don't have a will, the court is going to decide based on the hierarchy in the testacy statutes. It'll start with your spouse, then it'll go to your children, and then it'll go to your parents, and then your descendants of your parents, etc., 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 etc. If, for instance, you don't have a spouse, but you have a kid, but you don't trust your kid to be the personal representative, or you don't think they should be burdened with that, or they just aren't responsible enough, and you don't have a will, they're still going to become the personal representative, or at least be nominated as such. If you want to nominate someone else, maybe you have a life partner that you're not married to, then you need to have a will. Question number 3 is, do you have children? If you have children, you need to have a guardianship designation for when you die about who will raise your children. You can do this with a guardianship designation separate form. And you should probably have one anyways. That addresses when you're alive but incapacitated, and it can also address when you're dead. But if you don't have a guardianship designation form, the easiest and quickest way to do things is to put it in your will. Question number 4, and this is the big one, is do you have people in your life who should not receive an outright payment from your estate? So if you don't have a will, when they settle your estate, they're going to come up with whatever number your estate is worth. Let's say it's $500,000. And let's say you've got no spouse but 2 children. They're each immediately going to receive a payment of $250,000. It doesn't get stretched out over time. It doesn't get put into an investment account for them. They immediately receive a dump of money. That might not be a good idea in some cases. And it can cause real problems in some cases. For instance, if you have, if one of the people that's going to be receiving an inheritance from you is on Medicaid, or in Minnesota, the Minnesota state plan we call medical assistance. If they're on medical assistance because of a disability or because of age, then if they receive an outright payment from you, it might make them ineligible to receive the benefits. And this can be a real problem. To qualify for medical assistance, I believe in Minnesota, you have to have no more than $3,000 in assets. Now, if you give them a big chunk of change, they're going to have to spend that down and they're going to lose their benefits, and this can cause major problems. However, if you have a will and you set up in your will a testamentary trust, which is essentially a trust that is formed in the will, that trust can be structured as a supplemental needs or Medicaid trust, where you can actually give money to the person that is on medical assistance and not have them lose their benefits. That's really important to them. Another thing, reason you might want to give money directly to somebody is if they're children. Children in Minnesota under the age of 21 cannot receive an inheritance. If you don't have a will, it's going to go to court, and there will be a lot of attorney fees that are going to eat into your inheritance, and there's going to be a lot of court fees, as the court has to figure out a trust to hold the money until your child is 21. And then at the age of 21, they get the entire inheritance. If you don't like this idea, you might want to have a will with some testamentary trusts. You could have the trust hold the money until the child is 21, and then give them an income for every year of, say, $10,000 or $20,000 a year to help them live off of. Or it could say, here's $50,000 earmarked for education, or something along those lines. If you want to do something like that, you got to have a will. The final thing you might want to think about with trusts is if you have some people that need a spendthrift trust. And a spendthrift trust is essentially a trust that is used for somebody who isn't responsible or shouldn't have all the money right away. Children is one example, but the bigger example would be if someone has a gambling problem, a shopping problem, a drug problem, and they shouldn't receive $250,000 all in one shot. What if someone is probably going to have a divorce? You just see it on the horizon. If you give them the money outright, that money is going to be subject to the divorce, and a lot of it's going to go to the other divorcee. If you want to give a chunk of money to somebody but spread it out over time, or hold on to it until they're 30 years old and then give them the rest of the money, or something along those lines, then you need to have a will or a revocable living trust. The final question is, are you in a second marriage situation? Now, the reason I ask this, and this is kind of a big question, is take, for example, if you're in a second marriage and each of you in the marriage has a child from a previous relationship. What you would normally do, what a lot of people think they're going to do, is they'll make a mirror will. And so if one spouse dies, then they give all their stuff to the other spouse. And if that spouse dies, they give all their stuff to the first spouse. And when the surviving spouse dies, they split the money between the children. That's basically how a mirror will works. The challenge is, once the first spouse dies, the second spouse can do whatever they want. They can change their will. They can disinherit the child that's not theirs. They may get remarried to someone who takes advantage of them and takes their money. If you have a will, you can use a testamentary trust to set it up so that your spouse is taken care of with an income for life, and then after they die, the money goes to whoever you want it to go to, probably the children or something along those lines. You can't do this if you don't have a will. So that's my take on how much money you need to have to get a will. And the answer is, it's a question of strategy and need and circumstance, not of amount of money. If you like what you saw in today's video, please feel free to like and subscribe below. If you have any question, go ahead and ask them in the comments and I'll try to get to them. Otherwise, my name is Gregory Singleton from Signature Law.